Good afternoon, Mr. Chairman, members of the committee. I want to thank you for your work on this. I also want to thank Speaker Mattiello and the other sponsors, also Rep. Marcello and his sponsors, and really all of the legislators that have carried ethics legislation through over the last 7 years, and all of the people behind me who have testified on this. We're all links in a chain that I hope is getting finished this year, and it seems that it is. It's very exciting for us at the Ethics Commission. I hope it's exciting for you too. It's a wonderful time. The Ethics Commission generally tries not to officially support or oppose legislation, especially legislation that is going to increase or decrease its own jurisdiction. It's something that seems a little maybe unethical about that. So what the Ethics Commission does instead, and why I'm here today, is really to speak about the original intent of the voters in the 1986 Ethics Amendment and opine, give the Commission's opinion as to whether or not these proposals are consistent with that original intent. Because after all, that's what this resolution would do, is send some ballot measures back for the people to clarify their original intent back from 1986. So I want to talk a little bit about what the Commission has consistently, not just since the Irons decision, but since before then, has consistently believed are the three real principles that came out of that ethics amendment from the 1986 Constitutional Convention. And the first is to create an independent and nonpartisan ethics commission. And so the type of legislation that we would favor, or the resolutions we would favor, would keep the Ethics Commission independent and nonpartisan, and it looks as though this resolution would do that. The second important principle that the Ethics Commission looks at is to make sure that it's an Ethics Commission that has the authority to adopt and enact the Code of Ethics, to act as a legislative body in some ways to create the Code of Ethics. And for the reasons that I'll outline in a moment, it seems as if this legislation actually does preserve that also, which is a major consideration that the Ethics Commission is always looking at in this type of legislation. And finally, the third issue is, does the legislation support the people's original intent that the jurisdiction of the Commission is over all public officials to enforce the Code of Ethics? And enforcement meaning the right to investigate violations, to adjudicate violations, and to sanction violations. The investigative part and the sanctioning part are expressly mentioned in the Constitution. Phil West mentioned adding the words "and adjudicate" just to kind of close that final loophole, and I think that's a great idea. I'll talk about that briefly in a moment. So this resolution, Speaker Mattiello's resolution, has a few different moving parts to it, and what I'm here to say is that it seems that each part is consistent with these three issues that I raised before. It does restore the jurisdiction of the Ethics Commission, and it appears to do that in an explicit way. It adds a reference to the Speech and Debate Clause to the Ethics Clause, and it adds a reference to the Ethics Clause to the Speech and Debate Clause. Perfect. A roadmap on each side. The Ethics Commission does believe that an amendment to add the words "and adjudicate" would be an important step to ensure that we're not back here in 10 years. If we really want to fix it once and for all, adding those two words, they certainly add to what you're trying to accomplish, and honestly, I can't think of a single negative, even from your perspective, from the public's perspective, from the legislature's perspective, so I hope you'll consider that. The issue of the two-thirds vote for adopting portions of the Code of Ethics, the Ethics Commission doesn't find this to be a significant infringement on its authority to adopt a Code of Ethics. As was previously mentioned, it's currently a simple majority. A quorum of the Commission is 5. So if 5 of the 9 members of the Commission appeared at a meeting, 3 of them could vote to adopt a provision of the Code of Ethics, 3 of the 9. That's a very small number to do something that is so significant as adopt an ethics law. And so the idea of implementing a higher number, a two-thirds number, we think is rational and reasonable. And as Mr. West mentioned, generally most provisions of the Code of Ethics are unanimous or near unanimous, and so we don't see that as being a significant infringement on the authority to adopt the Code of Ethics. The complaint blackout, I've referred to it as a moratorium, but however you want to call it, blackout or moratorium. I don't know if it will surprise you to hear that the Ethics Commission isn't adverse to the idea of talking about a moratorium during the campaign season. In fact, in prior years, before this legislative session even, the Commission has discussed the issue and questioned whether or not there should be some type of moratorium. They've never entered the rulemaking process to actually really flesh it out, which is what is necessary. So the statistics don't lie, though. The Commission does note that there is a spike in complaints during the campaign season. We see some complaints are filed by political parties or political opponents of others. Sometimes they're good complaints, sometimes they're not. So the Commission is willing to consider the issue of a moratorium, and I think that what you've heard is correct in that, I think we really have to question whether or not the Constitution is the right place for a moratorium, as opposed to allowing the Ethics Commission to go through their rulemaking process and hold workshops and hear testimony from you and look at what other states do and really make sure that we've got a moratorium that is sufficiently clear and written well and that is temporally limited to the right amount of time. Maybe it's 60 days, maybe it's 90 days, but let's explore it rather than just throw it into the Constitution where we can't amend it easily, where it might take another 10 or 12 or 15 or 30 years to amend it again. I will say also that the way the moratorium is currently written, it's pretty vague. I know more than one person who has looked at it and doesn't know whether it's intended to prohibit people from filing complaints against candidates during the campaign season or whether it's meant to prohibit candidates from filing complaints during the campaign season. I think if you look at the language, you could read it either way. So we would ask that you consider either letting us take a crack at it, or you could take a crack at it through the legislative process. But let's hopefully consider not having that part of it in the Constitution. I promise you the Commission will take a really close look at it and is not hostile to the idea. The other provisions, I won't go into them in detail because I feel I've taken enough time, but I will say that in looking through the other provisions, we don't find them to be against those three main planks that the public expects in this. And so, I will simply just finish by saying that if this passes, if it goes on the ballot, something I noticed today, it would be on the November 2016 ballot. That's exactly 30 years from the time it was initially put on the ballot in November of 1986. There's some kind of beautiful symmetry to that, I think, that 30 years later we're able to correct what the public initially expected to have happen. And, in 1986, 144,000 people voted to create the Ethics Commission. And this is expected to be a record turnout also, perhaps, and so it'll be interesting to see how many people vote for it this year. I would expect it will be more than that. So I'm also here to answer any questions that you might have.
Thank you. Any questions for Jason? Yes, Representative Filippi.
Mr. Gamet, thanks. Thank you for coming.
Thank you.
Is it your contention that we can statutorily limit the jurisdiction of the Ethics Commission?
I don't know that you could statutorily limit the jurisdiction of the Ethics Commission, but a temporary moratorium that is very time limited, that would simply say that for a certain period of time the Commission won't hear complaints that other people file. This is another reason why it would be better, I think, out of the Constitution. We might want to consider only having the moratorium apply to third-party complaints being filed, but you might still need, the Commission honestly should still have the authority to initiate its own complaints at any time, especially because some of the complaints during campaign finance season might be a complaint about a candidate who didn't file his financial disclosure statement.
And I'd like to get to that, but it's the contention that we should remove the moratorium from this resolution, and that moratorium could be imposed either statutorily or through the Commission's rulemaking process. I would agree that you could impose a moratorium through your rulemaking process. I don't necessarily agree that once this is passed and put into the Constitution, that we would be able to statutorily impose a moratorium upon the Commission. So
It's a close question. There is concurrent legislative authority between the Assembly and the Commission, so the legislature has enacted certain provisions of the code that the Commission has then ratified and adopted, like the main provisions of the conflict of interest provisions. So between the legislature and the Ethics Commission, I'm confident that a moratorium that could be drafted that may make sense. I think it would be preferable for the Ethics Commission to take a crack at doing it through its rulemaking process, workshops, and public hearings. And I'm not prepared today to say exactly whether or not what role.
So certainly, and we're having a public hearing now, and I agree with you when you stated that we need to get this right.
Yeah.
We need to get it right now. My concern is that we put this important issue off to the future, and maybe the Ethics Commission and the legislature disagree about the legislature's ability to impose that moratorium at that time. And I think we are having public hearings now to vet out this issue. And so I would just want to state for the record that I'm concerned about assertions that we would have the ability to limit your jurisdiction in the future. And anyhow, moving on. This language speaks to the Ethics Commission shall not accept or initiate a complaint during that blackout period. Does Ethics Commission act sua sponte ever, or is it always a complaint-driven process?
Well, a complaint is always necessary to start the complaint process, but the Commission has the authority to initiate its own complaints, to initiate its own investigations, to conduct preliminary investigations, pre-complaint, and to file complaints. And each year, in fact, the Ethics Commission does initiate financial disclosure complaints against public officials who fail to file financial disclosure statements during the appropriate period of time. And at times, the Commission also initiates substantive conflict of interest complaints when there is ample evidence of a alleged violation and a member of the public does not file a complaint. The Commission may and has initiated its own.
So this blackout seeks to prevent not only complaints, but your investigatory complaints that are brought upon your own initiative. Am I correct?
It appears that that's the intent.
So would there be a way, I'm just trying to parse this, that this could be amended to prevent complaints during that blackout period by third parties, but not prevent complaints brought by the Ethics Commission during that blackout period?
I'm sure that could be accomplished.
Because if it was preventing third-party complaints, we'd take the politics out of it, which seems to be the concern, but we would still allow the Ethics Commission to bring its own complaint for allegations that may be out there publicly known.
Right. So that could be accomplished. The other issue I would just mention about it being in the Constitution is by tying it to the filing of the Declaration of Candidacy, which is currently, I think, the last 3 consecutive Monday, Tuesday, and Wednesday of June. You would know better than I would. So by tying it to that, remember that period is a statutory period. So if you're putting in the Constitution that the blackout period starts on that period, then what if that period gets statutorily changed to the first 3 days of April? Suddenly now it's an 8-month or 9-month blackout period. And so I would suggest if it's going to be in the Constitution, let's put a hard and fast period of time in there. Let's make it 60 days, 90 days, rather than make it a generic period.
Understand. Okay, I'd like to move on. In lines 11 through 12 on page 1, we speak to the assent of 2/3 of the members needed for adoption of every rule or regulation. Did you have any concerns that this would require your current rules and regulations to be affirmed or ratified by a 2/3 majority?
Well, I don't think so. I mean, regulations that have been passed in the past, I think, this is my off-the-cuff opinion, I think they would be entitled to de facto validity because at the time that they were enacted appropriately. Although at some point, even under the new Administrative Procedures Act that's being proposed this year, I think at some point all agencies may have to go back and reenact all of their regulations again. So there may come a time when the Commission would have to reenact all of its rules and regulations, but I don't foresee having to do that by a 2/3 majority as being overly burdensome for the Ethics Commission.
Okay. And speaking to the Code of Ethics, I'm trying to wrap my head around exactly what legislators would be prevented from doing if this were to be passed. So we wouldn't be able to introduce legislation where there's a conflict of interest, I presume. We won't be able to vote on legislation where there's a conflict of interest. Speaking on issues where there may be a conflict of interest, is that currently prohibited by your Code of Ethics?
Well, what the code prohibits is using your public office to bring yourself a financial benefit or detriment, financial impact, let's just say for shorthand, or using it to financially impact your family, your business associates, or your employer. So just simply speaking in general, walking down the hall and speaking, writing a letter to the editor, taking a call with a constituent, or sending an email is not really part of your public duty. It's not part of the legislative process or a core legislative act. But what would violate the code, I think, would be when you're engaging in what the term of art is a core legislative act, which would be a legislative act that you can only do because you're a legislator that involves the legislative process. So introducing legislation, sponsoring legislation, voting on legislation, participating in a committee hearing regarding legislation as a committee member, as maybe as opposed to just speaking at a public forum from a microphone like every other member of the public has. There is a public forum exception in the Code of Ethics that allows people to speak the same way that everyone else is allowed to speak.
But speaking on the floor would be prohibited even if you wouldn't take a vote.
I think it would be, and the reason I think it would be is because I'm not allowed to go on the floor and speak. So speaking on the floor is something that only legislators can do as part of their public duties. So when you recuse from something, you recuse from all of it. It's we say the same thing to members of city councils or planning boards. If you're going to recuse from that special use permit, it's not just recusing from the final vote. Don't participate in the hearing in any part of the discussion because you're using your public office to influence the way that the body is going to vote. So I think that's accurate.
And lastly, I looked at page 2, lines 1 and 2, and it speaks to any sanction issued against any party by the Ethics Commission shall be appealable to the judicial branch as provided by law. Currently, if the Ethics Commission has an adverse ruling, is that appealed by writ of certiorari? Is it a statutory appellate process?
It is. So my take on that language is that it doesn't change anything. Nothing will change, at least at the moment, that passes, because there already is appeal as provided by law, which is currently through the Administrative Procedures Act, which is a well-established set of appellate principles that allows anyone aggrieved by a decision of the Ethics Commission to go straight to Superior Court and seek a review.
But that's not a de novo review.
Not a de novo.
There's reliance on the factual conclusions made by the Ethics Commission.
Yes, but it could be de novo. Questions of law are reviewed de novo.
Could we statutorily, after we pass this, require a de novo review in Superior Court?
I'm not certain. You definitely could make the appeal different than it currently is. It doesn't have to be through the Administrative Procedures Act, so it could be a different type of appeal process. I would say that to the extent that it takes too much deference away from the Ethics Commission, then it could start to conflict with some of the other constitutional grants of authority that the Ethics Commission has. But it doesn't have to be the Administrative Procedures Act. There could be other appellate review, as long as there is some form of appellate review. I would say currently, by the way, the current system seems to work extremely well. The Irons case was an example of someone taking an appeal from the Ethics Commission and appealing it to Superior Court and then moving up to the Supreme Court on a writ of certiorari. So it's an effective avenue for someone who's not happy with what happened before the Ethics Commission.
Okay, thank you, and thank you, Chairman.
Vice Chair Costa.
Thank you, Chairman. Just for clarification, something that you said when you were talking to Representative Filippi. If we have a bill coming up and it's we're voting on a fire district, or we're voting on firefighters, which we do have a handful of firefighters on the House floor. Say if we're voting maybe pension reform again, or something to do with the teachers, the firefighters would have to recuse themselves and not argue this on the House floor, and the same would be intact for the teachers?
No, probably not. And this is one of the things that I used to discuss in some of my prior year's testimony. So there is currently, and there will always be, a class exception written into the Code of Ethics. And every state that has a Code of Ethics, you have to have a class exception. The class exception says that even though maybe there's a financial impact, to the extent that the impact is one that a significant class of people are all feeling, and you're in that class, but you're just one of a great number of people, everyone is impacted the same way, then you are allowed to participate. And the Commission, I could show you, and it used to be part of my testimony, I could show you advisory opinions that we've issued to legislators. We have probably a dozen or more to legislators who are teachers or firemen or police officers saying you can vote on pension reform issues, even though you're impacted because you're just part of this really big class. We've got advisory opinions we've issued to lawyers saying you can vote on laws that impact domestic practice or family law, even though you practice in family law, because you're just one of many. And we've got advisory opinions we've issued to legislator dentists that we've allowed them to participate in bills related to the general practice of dentistry, and so on. That's one of the things that's really going to benefit legislators, and one of the things that's going to keep us really busy if this all passes is, we'll be back to writing you advisory opinions, so that if you have a question about a particular bill, and maybe you're even getting some pushback as to whether you can participate, you can go through our advisory opinion process and get an opinion in writing that says that it does not violate the Code of Ethics for you to participate in this type of class exception behavior.
Thank you so much.
Rep. O'Grady, do you want to hop in here? Okay. Representative McEntee, would you like your votes recorded?
Yes, Mr. Chairman, please. Thank you, Mr. Chairman. My question was, since the ethics rules apply to all elected and appointed officials and employees of the state and local government, of boards, commissions, and agencies, so if during this blackout period, if someone were on, say, town council or planning board or zoning board, would they be exempt from any kind of ethics issue in their capacity as zoning on the zoning board or city council or town council? Would they be exempt completely because they're running for office? I mean, for us in the legislature, we're not generally in session on the end. Oh, I shouldn't say that. It could happen, but at the end of June through November. But obviously, town councils, city councils, planning boards, zoning boards, employees of all different capacities are, still functioning during a campaign.
I think as written it would apply. So if you're on a zoning board and you're running for council in your town, and someone claims that you had a conflict with the special use permit for the construction of whatever that was, then the blackout period would apply and the commission would be prohibited from accepting that complaint.
Seems like a broad brush when you look at it that way, if you're continuing to do, your other duties. But
well, this is one of the reasons why I feel that opening it up to having public comment, where we solicit. This is how we generally go through rulemaking at the Ethics Commission. We actually solicit comment from the cities and towns if things are going to impact cities and towns. We solicit comment from state elected officials, and the idea is to not be rash about something that has so much impact. For putting things in the Constitution is serious business, and it requires serious consideration. So.
Thank you.
Yes, back to Representative Filippi.
One more thing. The Ethics Commission has been around since 1986, am I correct?
Right, and there was a predecessor state statutory agency before then even.
Certainly. So in the past approximately 30 years, has there been an attempt by the Ethics Commission to impose a blackout?
They have never initiated rulemaking to explore it. It's beginning in about 2014, we can find a reference to the issue in the minutes of the Ethics Commission's meetings where the chairperson and the staff have discussed that maybe we should start to take a look at the types of complaints that are filed during the election season and consider whether there's any type of policy that could be implemented to address it.
Thank you.
Any further questions for Jason? Representative Craven.
Welcome, Jason. Thanks for coming. And with reference to the blackout, as it's being referred to, I'm not sure I'm comfortable with that language. But your point is well taken in reference to the Ethics Commission itself not being able to initiate a complaint during that period of time. Let me ask you, what is the process of the Ethics Commission initiating its own complaint? Can you answer that for me?
Sure. Well, there are a couple different ways it can happen. First of all, we would only initiate our complaint if we were satisfied that, for us to initiate a complaint, we pretty much would only do so if we internally felt that there was probable cause probably to go forward. At that point, we wouldn't just initiate an exploratory complaint. The process for a preliminary investigation, which we do have at the Commission, allows us to, even pre-complaint in a confidential way, to start conducting a preliminary investigation, to compile documents and talk to witnesses, and we notify. And if we determine after that, and it's time limited, if we determine after that preliminary investigation that the evidence is sufficient to warrant the filing of a complaint, then we're allowed to file a complaint, which just starts the full investigation process, and suddenly all the due process procedures will come into play in terms of. So
it's safe to say that, I'll just use a word that I'm comfortable with, and you can let me know whether you're comfortable with it, that there's a vetting process, a screening, so to speak, process that the Ethics Commission goes through before it initiates an investigation, never mind a complaint.
That's absolutely true. And this is what I'm about to say. I think you will understand that it's true, and that is the only way the Ethics Commission has lasted for 30 years is by scrupulously maintaining an air of fairness and impartiality and nonpartisanship and independence. And if we stopped doing that, if suddenly we were filing complaints willy-nilly at the drop of a hat, you have some options. There are checks and balances to what we do. Even though we're an independent agency, there's still the appellate process. We still have to comply with due process. We still have to comply with equal protection. You still have budgetary authority over the Ethics Commission. You still have concurrent legislative authority over the Code of Ethics. So there are checks and balances all over, and for 30 years we have a pretty good track record of deserving our reputation as being fair, and the Commission will always guard that with the filing of complaints.
Would it be fair for me to assume that, since you just referenced 2014 minutes of the Ethics Commission's meetings where they discussed the possibility of moratoriums or some other process during the election cycle, would it be fair to say that those were not internally generated complaints, but rather complaints that were received externally to the Ethics Commission?
Absolutely. The Ethics Commission isn't filing complaints during campaign season against candidates. That's not.
Why?
Well, I mean, we're not trying to influence we're trying to stay completely nonpartisan. And it's funny, if you look at the comments to the Projo, or if you listen to talk radio, the people on the right are convinced that we're favoring the people on the left, and the people on the left are absolutely certain that we're favoring the people on the right with the way that we handle these complaints. So So we're always taking steps to avoid anything that could even be the appearance of partisanship.
Right. And my last question, would that not seem to make sense based on your own experience as legal counsel at the Ethics Commission, that if there were going to be a moratorium, it would exclude the commission's generated complaints, but include exterior complaints from the public during a blackout period that may or may not be adopted in this legislation?
That would make the most sense to me. If we were to file, say, financial disclosure complaints against candidates, it would be the same way we file them against, incumbents, which is to say what we do is we take a category of people. Let's say all city council members across the state. If you were running for city council and you didn't file a financial disclosure form, maybe you'll get you may have a complaint filed against you, but it wouldn't be just the city council members in this town or that town or of one party or the other. Anything that the commission ever does when it's filing that type of financial disclosure complaint, it's always broad-based, a complete category to avoid any type of partisanship or favoritism.
Thank you.
Thank you. Any further questions for Jason?
Thank you.
Thank you very much.
Thank you very much.